Let me welcome Abhishek Singhvi to the show this evening. Mr. Singhvi, thank you very much. You are the man who's got Mr. Kejriwal bail, and God knows it has not been easy. Can I start by asking you to clear some confusion over what exactly are the bail conditions as far as Mr. Kejriwal is concerned? He can't go to the secretariat, he can't sign any files, which means Mr. Kejriwal is free, but Delhi's chief minister is still behind bars or still caged. Is that a fair assessment, sir?
Thank you, Shreya. Well, it's good. A much-deserved bail has been granted, even though belatedly and even though after a attempted frustrating arrest in end June by CBI. But that's a different story. Let me come to your specific question. People forget that this is not a new condition imposed. It is, the order says that exactly the same conditions imposed on the 12th of July, earlier Supreme Court order, which I had the privilege of arguing for in the ED case, those conditions shall apply. That's point one. So this is not a new set of conditions. Second, people also forget, and this is the misinformation going around in some channels also, calling him, bound Kejriwal, even though CM, but bound CM, etc. Well, people forget that he's a minister without a portfolio. He has never had a portfolio. So he doesn't sign any files at all except one category. That category is those files which have to be signed under the system we have in the dual rule of Delhi, which have to be signed which go from him to the LG. That's a limited or a specified category of files. Now for that signing, this order of 12th July, not today's, allows him to sign. And so does today's order, which copies that order. So, by saying that you can't sign files, the court is not really excluding him in any manner in terms of the fact that he is not required to sign any file for a portfolio which he doesn't hold. But yes, to the extent his signatures are required to send it to the LG, he is allowed to do so. It's point number two. Point number three is that independently, I don't agree, and one learned judge has expressed the same reservations in today's order. I don't agree with the indefinite continuance of these conditions. They are born out of a certain temporariness, a certain intention that while some active investigation is going on, the person should not, be dealing with those issues. Well, I think the stage is now far past anything of that sort, because you've had in various, all the matters I've done, the Kejriwal matter, the Sisodia matter, so many others, all of them have 6th, 7th, 8th, 9th, 10th supplementary charge sheets. And all documents are done. So time must come when even this limitation must go. One learned judge or two judges has expressed great reservation, rightly so. Because remember, in a democracy, the only way I can remove you as an elected person is through the electoral process or through use of articles like 356. If the people want you again and again, you cannot fetter or remove me, except that you can punish me for some criminal act. But suppose in that criminal act you get bail. You cannot separately punish me on that bail condition. And now there are judgments otherwise also which say that a bail condition which is so onerous as to take away from the right hand what is given by the left hand will not be allowed. Justice Oak's judgment has come on that. But that apart, this is not that kind of a condition. It is a continuance of an earlier condition. It will go in due course as time goes on. And today, he is not in any manner fettered from signing any file which requires him to sign it to go to the LG. So governance cannot be in any manner impeded.